Hello, everyone. Thank you for joining my deep dive again here this January, April 29th. I put out earlier this week and last week when FTC announced about banning non-competes, and I was sitting here and I started asking a lot of folks about, what do you think about it? Are you going to talk about this? And a lot of entrepreneurs, especially in my industry, was like, well, I'm not even going to talk about it. I'm not even going to bring it up because that sounds like a can of worms. Well, anybody that knows me is I have no problem bringing things like this up. I think we have to talk about it. And with that, I have the privilege of being part of a really cool networking group called Provisors. And that group across the U.S. is really made up with a lot of legal counsel, and so I get the advantage of getting to talk to these guys a lot. And so I've reached out real quick and asked if someone would actually like to join, and Adam and Bob responded real quick. And I'm gonna let them introduce themselves, but it really nice. Adam approaches this from an employer side, and whereas Bob approaches this from an employee side. So it's perfect. We got an entrepreneur, we got the employer, and got the employee sides all here, and we're gonna talk about and get ideas of that. So with that, Adam, I want you to do a quick intro, and then Bob, you can follow him up.
All right, thank you, sir. So my name is Adam Dougherty. I am a partner with the employment law firm called Ogletree Deacons. We have about 60 offices all over the country and globe, and we're pretty unique in that all we do is employment law and kind of everything under that big umbrella in representing companies. Been doing this for almost 25 years and all of it on the employer side. So do a ton of non-compete litigation, advice, also drafting. So I'm definitely appreciative of your invitation and excited to be here.
Thank you. Bob?
I am a lawyer who exclusively represents employees. I've been practicing for 44 years, 33 of that for employees, doing employment law and benefits cases. And that is really everything except for union-related litigation or collective bargaining agreements. I love what I do, helping the little guy, which is basically what it amounts to in every case. And the part of that is dealing with, in Texas at least, over the last 33 years, non-competes, non-solicitation agreements, trade secret issues. So this trend towards changing the law is very interesting to me, and I hope that it comes about in a major way.
Well, I appreciate that. Well, thank you guys for being here. When I read this and the FTC coming out there, as an entrepreneur, one of the things that first popped in my head is, I have non-competes, and I come to this, and I've dealt with non-competes for a long time in the enterprise space as well as what I'm doing this. But to me, my mind goes to what am I really trying to protect? When I think about it from an employer standpoint, I think in everything I think about what I'm trying to protect is I'm really talking about non-solicitation. Don't take my client list, don't go out, leave and try to take all my clients away, and those type of things. But in this, what they're saying about banning the non-competes, it really is targeting is the general employee, but like senior executives that have certain type of things, those non-competes will not necessarily be affected. I've talked with some folks that saying that non-competes, depending on the state you're in, some of them are easy to beat and other places it's not. What I want to do real quick is, from my perspective, I know for me, non-solicitation is the biggest thing I focus on. And so I don't too much worry about non-disclosure, the non-compete. I'm more worried about that. But walk us through this, where you think FTC is going to go with this and how you think this is going to happen, because some folks of us like me and others, it seems like there's starting to be a little bit of an overreach from the federal side into what you see a lot happens. Each state has its own type of thing. So from the employer side, what's your view on this, Adam?
Yeah, and let me start with a little bit of context. I think Bob will agree. I think, sometimes we call non-solicitation agreements non-compete agreements, and there's some overlap. So the way I help my clients try to think through it, I think there's like four buckets when it comes to non-compete restrictions. The first is what I call a pure non-compete, which means you can't go work for a competitor. The second would be a non-solicitation of customer restriction. A non-solicitation of employee restriction would be the third. And then the fourth would be a restriction on the protection of confidential information. And so when you get into that fourth bucket of confidential information, that type of restriction is even lawful in California. So I think we can kind of wrap our minds around it. And there might be some nuances in each state, but generally speaking, even in California, if an employee signs an agreement protecting confidential information for one employer, he can't use it for the other, and that would, generally speaking, be enforceable. Take that pure non-compete restriction, though. California, that's per se unenforceable. Compare it to Texas. Here, with some nuances to it, pure non-competes on the books are still enforceable like they are in a number of states. Across the 50 states, I do a lot of multi-state drafting of non-competes. There's been a trend in the last few years, kind of led by California. Typically, when California is leading the trend, it's more pro-employee versus Texas, which is more pro-company. And a lot of the more pro-employee states are having state legislation on the books that will limit, restrict, preclude altogether all these first three non-compete restrictions, whether it be the pure non-compete, the employee non-solicit, or the customer non-solicit. So with respect to the FTC rule, on its face, and I'll say from a high level, I think the FTC would say its rule is just affecting the pure non-compete part. That's their main goal, to get rid of these pure non-competes. You cannot go work for a competitor. So in other words, like Bob, we were chatting offline, it's very similar to what California has done. And in the FTC rule, it actually says you have to notify your employees, your ex-employees, that their pure non-compete restrictions are no longer effective. So there's even a duty to notify them, not just to say, okay, no harm, no foul, we'll just leave it out there. So from that perspective, I think that's what the law is trying to stop. But like a lot of laws, when you read it together, the test for what's a non-compete can arguably extend into the non-solicitation of customer area, the non-solicitation of employee area, as well as that confidential information and trade secret area as well. So I don't want to steal the show here, Bob. Do you have any comments? And we'll try not to get into heated of a debate as if we're in court here.
I'm fine with that. The non-solicitation of employees, or anti-rating provisions, as some call them, are really not that important, except for managers who have a following with subordinates who, if they leave, might wish to have those same subordinates be subordinates in their new employment, or think there is some value in hiring from the company they've just left. But it's not the principal concern of most of those who are affected by non-competes or non-rating provisions or proprietary information protections. I agree with Adam that the line is not clear under the FTC rule about how it affects non-competes versus non-solicitation provisions. But in Texas, supposedly, and this gets worked out on a case-by-case basis, non-solicitations agreements, to the extent they, and it's almost in the same language as the FTC rule, to the extent they functionally operate as a non-compete, are also subject to this rule of reason, this what are the facts and circumstances? Is 10 miles a reasonable limitation? Is the whole state a reasonable limitation? Is the whole country a reasonable limitation? So there is nothing radical in the FTC rule, to the extent that it says if non-solicitation agreements have the effect of a non-compete, then they're also voided under the rule. And I think, and Adam may know better than me about how much that represents California law or the law of other states, which ban the naked non-competes, as he put it. But the concept that that people, and I think you're right, Wayne, the main way that a practical businessman considers non-competes is is in their effect to prevent somebody from going after their customers. Sometimes existing customers. In some agreements, it talks about prospective customers, customers of the entity, even if the employee never dealt with those and may not even know those in some circumstances. So I think that where the rubber meets the road, assuming the validity of the rule, there's litigation, as we discussed, that has been filed already, and that may suspend enforcement of the rule for some time, may or may not. The rubber meets the road when it comes to how non-solicitation agreements are going to be dealt with, whether there's any reasonableness requirement that's imposed, or whether non-solicitation of customers, say with whom the individual dealt, is functionally equivalent to a non-compete, which I think it is. That's as close as you can get, as opposed to prospective customers of the entity or prospective customers of the individual. If they dealt with a customer, then seemingly that's the easiest case to say amounts to a non-compete. So.
Okay.
Yeah. So
well,
go ahead, Wade.
I'm going to put a little bit of a twist on it.
Yeah.
For some of us that doing an M&A, so like I'm going to purchase another company, right? And they got their employees and they've got their customer list, and I've got all that. And now I'm doing an asset acquisition then, and I'm bringing them in. Now I'm extending job offers to those employees and bring them in. But how would non-competes affect, if I'm going to acquisition like that, those employees decide, I don't want to go work for this company that's doing that acquisition, and then they go off and try to take customers or do that kind of things. How does this affect that scenario with what the FTC is saying they're going to do?
If they have not been subject to a non-compete already, with the requirements under Texas law for a non-compete to be enforceable, and it's not enforceable just because you pay the money, by the way, that then they're not restricted if they decide not to become an employee of the acquiring entity. Under the FTC rule, seemingly the situation wouldn't be any different because they don't have a non-compete in the first place with the entity which you're acquiring. If they do have an agreement with that entity, as Adam said, the naked non-compete is clearly in violation of the rule. Whether if there's a non-solicitation aspect to it, that's where the question will come up.
Yeah, and I'll add to that. So in the FTC rule, there's actually an exception to the banning of the pure non-compete, and it is for the bona fide sale of a business.
Right.
So you can have a non-compete with the owner who's selling, but and that would be valid, and that kind of makes sense. And I guess the thinking behind it is they're sophisticated, they're getting money, they know what they're getting themselves into. But it doesn't trickle down to the workers who might be then transferring to the new owner, the new company. But it does apply to the sale of a business to the high-level business owner.
Right.
But the interesting part, going back to this non-solicitation, which I think is, if the rule survives the challenge, which we can talk about in a few minutes, that several lawsuits have already filed and laid out some pretty compelling arguments from my perspective. The test for what meets a non-compete, there really isn't a federal definition of that. So the way the FTC defines it is whether the restriction functions to prevent a worker from seeking or accepting employment, right? So whether the restriction functions to prevent the worker from seeking or accepting employment. So with that definition in mind, it's not like it says, I think Bob's using the term naked non-compete, I'm using the term pure non-compete. It doesn't specifically just say that. In my opinion, it's very broad, it's very vague, it's very open into interpretation. And so I think that's, one of the, in some of these lawsuits have been filed already, that's been one of the challenges to the law, is that it's impermissibly vague. But let's say it survives, that's where the litigation's going to happen. And, like Bob was saying too, when it comes to these customer non-solicit restrictions, I can see, an employee challenging it on this basis, especially if the restriction in question says you can't solicit any customers of the company. So let's say the employee signed that, and then he's thinking, or she is thinking of going to a competitor. I could see that individual challenging, using this new FTC law, challenging that type of customer non-solicitation, saying that the broad nature of it would function to prevent me from seeking employment if I can't solicit any customers. There's kind of been a trend in Texas and other states where, it's not necessarily a black letter law, but it is a trend when you're drafting the non-competes to limit those non-solicitation restrictions to customers that the employee actually solicited, which I think practically and from a policy perspective makes sense, because what would be the employer's motivation or legitimate reason to prevent an employee from soliciting customers that the employer has that the employee might not even know exists, right? So I think that if the rule survives, I could see the first challenge to the law, or not challenge, but somebody trying to use it to their benefit for being a non-solicitation restriction like that covers all company customers, not just the ones they solicited.
And that was the distinction I was making, Wayne.
Yeah, that's what I was going to say. That sounds like exactly what you were saying there. And from an entrepreneur standpoint, when we talk about that client list, typically those employees that have access to what like in my industry is what's called a PSA, it has all our clients in it, all that information, and they have access to that. Well, because if they have access to that and can see that, it's got all the contact information of the client, what we're doing here, we would have to, in a non-solicit, actually word that very tightly around that information. That makes it viable if we narrow it in and really call that stuff out, correct?
I think there still needs to be a distinction between those the individual had dealings with and those that may be customers of the entity but they never had dealings with. For example, somebody may be in one division of a company that deals with a certain type of customer and never deal with another type of customer. From a policy standpoint, from a moral standpoint, from a kind of non-FTC legal theory standpoint, it probably is going to be necessary to focus on those with whom they had dealings. And because the argument is they have the advantage of knowing who to contact, cell numbers, email addresses. I mean, those are more readily available now, but they're still viewed as precious information from a customer list standpoint. And if they don't have information about many customers of the entity, but only 20% of them, then the focus should be on the 20% because that's the only place they really have an advantage over any stranger.
Okay. I see what you're saying there, Bob. That makes sense. Okay, let's turn a little bit and let's talk about the lawsuits that come out pretty quick on this and what validity they have and where you seeing those things go and how that's going to affect, say, the next few months with this.
Yeah, so there's been a number of them. Probably the one that's getting the most press is from the U.S. Chamber of Commerce. So I think it was filed either the same day that the law was issued or the very next day. I mean, they had it ready to go. It's basically being challenged on 4 different grounds. We've kind of touched on a few of them. Just from a big picture perspective is whether the FTC has the authority to even issue a rule like this. Another challenge is that it's making these non-competes categorically impermissible as opposed to having carve-outs that might be based on studies or less anti-competitive effects. Another challenge is that the rule is impermissibly retroactive to where you have to go back and inform these employees that their non-compete is no longer effective. And just to add too, there is an exception to that, and it's for senior executives who are making over around $150,000. So they still can't, according to the FTC, you still can't enter into new non-competes with them, but the retroactive ones for them are still in effect and you don't have to give them notice. And then, going on what I touched on, the fourth ground is that the rule is basically arbitrary and capricious. You might say vague over broad. It's kind of a nice legalese term to say, hey, this is just not good, you know? And so, you know, from my perspective, being more pro company, pro employer, I look at, and I'm sure Bob will have a differing opinion to this. You know, like I was saying at the start, all these states have really jumped in saying, and we're talking like Washington, Oregon, you know, the more pro-employee states, Colorado, Chicago, Illinois, and they have, you know, really carefully thought it through, had their state legislature pass it, where they add all sorts of restrictions, including salary thresholds, including that you have to give notice before the employee starts of the non-compete in some states. Some states have even passed limitations on that fourth bucket with respect to the protection of confidential information, where they say you even need to put a time limit on that, right? So from my perspective, yeah, I do look at this as being an overreach by the FTC, and I think it's one at the end of the day that is ultimately unnecessary because the states that feel motivated by what their citizens want have passed legislation to deal with this. And there's really, you know, it's really California that I think is the outlier where they're like, they're gone no matter what. You know, there's maybe one or two others. Most have, you know, kind of created exceptions, carve-outs, limitations that maybe in a lot of people's minds make the pure non-compete more fair, where it's executives, high-ranking people, you know, somebody, if you lose them to a competitor, just, you know, whether they take any confidential information, whether they, you know, call a customer directly, could do harm to your business. If your right-hand man or woman leaves and goes to your biggest competitor, you know, most companies are not going to want that to happen. So from my perspective, that's kind of where I'm coming from. I think given the political climate of our country, I think the law will be successfully challenged. It'll ultimately make its way up to the Supreme Court. I suspect the Supreme Court will strike it down.
Bob, what's your view on it?
Well, just one point of clarification on, because salaries of $150,000 are not that uncommon today. Our firm is seeing potential cases every day, and the number of employees whose salaries are over that is kind of stunning to me, who are dealing with employment issues and not just non-compete issues. But it does require, the rule does require not only the salary, minimum salary, but that they truly be senior executives with a policy-making role. So it's not just the salesman who is making $150,000, it's the upper-level decision maker. So that's one point. On the general challenge, as a practical matter, the question is whether enforcement of the rule is enjoined, which means a court stops the FTC from enforcing it for a period of time. The issue of nationwide injunctions has become more controversial. The mifepristone case in West Texas is an example of that. Even among conservative politicians and jurists, the notion of nationwide injunctions by courts where there's only one judge sitting, so you know, so it's basically forum shopping, you know who you're going to get. That's become an issue. I noticed that one of these cases, and it may be the Chamber of Commerce case, maybe another one that was filed in the Eastern District of Texas, which does have more judges, but in certain of its divisions only has a few judges. Like, I don't know if you know, Adam, if this was filed in Marshall, where there are only two judges, really only one district judge and a magistrate judge.
Right.
So I think the ability to get a nationwide injunction is probably less than it was 2 years ago, just from the standpoint of the judiciary's view of that. Even our Court of Appeals, which is very conservative, has tended to not just approve that whole cloth. In the mifepristone case, they shaved it back, for example. But I won't agree with Adam that it's certain or highly likely to be rendered unenforceable when it gets to the Supreme Court. The FTC has established federal antitrust policy for 100 years, or more than 100 years, since the Sherman Antitrust Act was was enacted. My point of view would be that, and I hope it gets defended on the basis that the Sherman Act and the Clayton Act, which are the antitrust laws, can get adapted, I should say, to new circumstances, just like they have with the Apple lawsuit that's been filed recently and other tech company antitrust lawsuits. They should be able to, the FTC should be able to do the same with this individual form of restraint of trade. And in most states, if not in all states, there's what's called by lawyers a common law, that is not in a statute, a common law disfavor of restraints on trade. And to use the Texas term, boy howdy is telling you can't go work for another company for some reason, a restraint on trade. And so I don't think realistically there's the opportunity for compromise of the issue. That would probably take a political situation which could enact a law at the level of Congress to embody a compromise. But there have been similar attempts in the context of arbitration provisions in the employment arena. Well, there have been legislative attempts. They have not succeeded yet. But it is a possibility. It's a remote possibility.
Okay. So let's take this last question and we'll wrap up from this. But what would your recommendations be? Adam, you from the employer standpoint, Bob, you from the employee standpoint. What would your recommendations be to those two entities in the near term, educating themselves, what they should watch for? What should we be doing over these next few months as this is being decided?
Sure. Well, what's interesting is the Chamber of Commerce case. The judge there, the chamber basically filed or the defense filed a motion to dismiss, and the briefing schedule is a really fast one. So it should be completed by my notes by May 28th, right? So we're talking really just less than a month away when we should have the court's ruling on whether the law, at least at this introductory level, should be thrown out. So I think it will be appealed very quickly up through the appellate court, then to the Supreme Court. But I don't think we mentioned, and it's an important part of the rule. It's 120 days before employers have to comply with it. Right. So I think part of the reason of this expedited briefing was to fast track it to hopefully get a ruling from the big guys and gals before the 120 days expires. So we're basically telling our corporate clients they basically have three options. One is basically do nothing at all, see how this plays out. And the other is to embrace the potential future and kind of get ahead of it, where you're actually reaching out to your prior employees and telling them the agreements are no longer existing. And the other is kind of a middle ground, which I think a lot of employers will do, where they'll basically sit tight, not reach out to any prior employees, tell them your non-compete's gone, but I think they'll probably sit tight and also not roll out any new non-compete agreements, at least to see how the litigation plays out.
Okay. How about you, Bob, from the employee standpoint?
I think there's another federal government mandate that applies to fewer employees through the NLRB, and it's been invoked. It's in effect, and it's been invoked in some cases by our firm. I know I don't know at this point whether it remains subject to a judicial challenge. Its effect is narrower, so they may not be as potent. But our advice is going to be to, again, not put up a billboard about what you're doing in your next job. Be conservative, but most of these non-compete lawsuits, on other than the high executive level, are resolved by an agreement not to approach certain named customers, an allowance of approaching other customers. It's not like most of these cases get tried. They get resolved at the early stages, as you know, and I think that this will be just a potential arrow in the quiver, but it's very legally uncertain until we hear from a court, until we know whether it's going to be enjoined at all or enjoined on a nationwide basis, whatever.
Okay. All right. Well, Adam and Bob, I really want to Thank you all for joining on, especially on a quick notice. This come out last on the 23rd. I sent you guys an email the very next day going, hey, y'all want to jump on and talk about this. So I appreciate y'all jumping on. And if anybody has any questions, I highly recommend y'all reach out to these two guys, the group that they're part of, that I'm part of. I meet a lot of fantastic people, and these are two of them, so I can't say enough about them. But if you got any questions, you can get with me, you can get to the website, you can come in and reach out to these guys. They'll be more than happy to help you any way that they can. Guys, y'all have a great week. I really appreciate y'all's time, and I'll see y'all at the next meeting.
All right.
Thank you very
You're
much.
welcome. See you guys.
Thank you.
Bye.